intentionally mean for this to happen.
But you can't tell us why you left him in there and went upstairs.
Welcome back to another episode of Grizzly True Crime. My name is Grizzly K, and today we're back to talk about Sarah Boone. If you've never heard of this case before, I'm going to link the deep dive we've done before, where we looked at this entire presentation that I made for you, the timeline, documents, the police interview, everything. So that will be linked for you in the description box. I'll also put it somewhere up there. But I just wanted to give you a quick recap before we dive into the updates today, which includes a little clip from Sarah Boone's motions hearing yesterday. Remember, she's now defending herself. And it's actually amazing that she won this motion because she has no lawyer helping her, right? Okay, so we're going to look at that update. We're going to look at a news clip from that. We're going to look at documents and 2 of her latest letters. So I guess we could safely say buckle up because, my goodness, Sarah Boone, she's a little bit like Daryl Brooks. If you saw that trial, you'll understand. It's just, oh my word, she's a very busy one. She has every right to defend herself. I'm fully aware of that. It's just like, whoa, some defendants are just a lot. They take a lot more energy than others. And this judge, oh my goodness, he has the patience of a saint. So it's kind of like Judge Dorrow, which we've seen with Daryl Brooks. Yeah, this poor judge. Anyway, so we're going to look at that. Let me just give you a quick recap of what happened in this case for anyone who doesn't really know, or if you just want a refresher on the dates.
Please note that this content is for adults only. Viewer discretion advised. If you haven't yet, hit the subscribe, like, and share.
So on February 24th of 2020, yes, it's been more than 4 years now, and the case is yet to go to trial. The trial should be starting on October 7th of 2024 after multiple delays and 8 attorneys that Sarah Boone has worked through. October 7th, 2024 is in my diary. Many previous dates were scratched out, typixed out, all of that. So for now, we're going to remember because the judge said it is happening. It's not changing again. She's defending herself October 7th, 2024. Let's see. Now, on February 24th of 2020 at 1:01 p.m., the Orange County deputies responded to a 911 call that Sarah Boone made telling them that her boyfriend was dead. She had first called her ex-husband, who came over to the house, and he advised her to immediately call 911. Sarah says they were drinking wine the night before, putting together a puzzle and doing some art together, and then they decided to play some hide and seek. And when George didn't come upstairs to look for her, she says she went downstairs, and they both thought it'd be funny if he got into a suitcase.
My boyfriend and I were playing last night, and I put him in a case and we were playing, and like kind of hide and seek kind of thing. So I fell asleep, and I woke up, and he was dead in the suitcase, so I don't know what happened.
Sarah says she then went back upstairs and fell asleep, and when she looked for George the next day, she realized he was still inside the suitcase. Note, she last saw him at approximately 12:30, so midnight, and called 911 at 1:01 p.m., 12 and a half hours later. When the police arrived, they saw that George had lacerations on his lip, bruising on his eye, scratches on his neck and back, and they asked for Sarah's cell phone, which she willingly handed over, and they discovered 2 disturbing videos of George in the suitcase begging for Sarah to let him out. Now, if you've never seen those videos before, please, it comes with a trigger warning. It's extremely distressing. So Sarah Boone zipped him up in a suitcase in what she says was a game of hide and seek, which just seems so unlikely. Like if it's hide and seek, the person would hide and then you would seek. You wouldn't hide them in a suitcase, you know what I mean? And then go upstairs and forget to look for them. That makes no sense. So anyway, it's very disturbing videos. We have looked at them before. Again, it's on that deep dive. So if you want a complete refresher of the case, if you've never really done a deep dive, then I'd recommend that video. Okay, now let me show you what she has just recently won in court, which was quite amazing to see. That's one of the first wins for her after many letters to attorneys, to the judge, to detectives, to whoever. She writes a lot, okay? She's very, very busy with pen and paper from the jail cell. Okay, she's also, if you didn't know, facing second-degree murder charges. I believe she's using the battered spouse syndrome defense, so that's going to be interesting. And you know this case happened in Florida. So I don't know how that's going to tie in with zipping someone into a suitcase, honestly, you know. So anyway, okay, so this is what happened now. This is the most recent news. They said order and notice of hearing. At the time of this recording, it is August 10th of 2024, okay? So this is State of Florida plaintiff versus Sarah Boone, defendant, order and notice of hearing. This cause came before the court on August 9th of 2024 on motion for the defendant's reasonable freedom in movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably, while utilizing the courtroom, hand filed on August 5th of 2024, the motion. Because again, she's now defending herself. Sarah Boone has been through so many lawyers and called them buffoons and literally pissed them all off and chased them all away. Some there was a conflict of interest, okay, so it's not like all 8 were chased away, but still, oh my goodness. And each time they assigned a new lawyer, we're like, is this the one? Shame. Is this the one? No. Now she's defending herself. The judge said, no more, we draw the line, you're now defending yourself. Of course, she's going to complain about it. However, they say the motion, because she filed a motion, you know, by a letter, writing letters to the judge and wanting this to happen, to be unshackled, unhandcuffed, so that she can move freely in the courtroom when she's going to defend herself. Because she said when she's watched other trials, she could see people move freely. If you remember, for example, Ted Bundy moved very freely in the courtroom, you know. So I think she's thinking she's going to be like putting on a full performance. So the courtroom hand filed on August 5th the motion. The court, having reviewed the motion, having reviewed the court file, having considered the testimony and evidence offered, having considered the arguments offered by counsel for state, and having considered the arguments offered by the defendant, hereby orders and judges as follows. I can't imagine when she's reading this, she must be like, yes, I'm a lawyer now, right? The motion is granted for the reasons placed on the record. The procedures for hearings and for trial as placed on the record shall be complied with by the defendant. Prison break investigations by and through investigator Billy Lane shall take the discovery that was provided to the court on June 28th of 2024, the discovery, and shall provide the same to Major Malik X. Muhammad at the Orange County Jail today, August 9th, 2024. Prison break investigations by and through investigator Billy Lane shall take possession and custody of USB jump drive, which contains the state's digital evidence tendered in open court on August 9th of 2024, and shall provide the same to Major Malik X. Muhammad at the Orange County Jail today, August 9th of 2024. Prison break investigations by and through investigator Billy Lane shall provide the digital transcripts of depositions of detectives Chelsea Kupsel and Scott Lowen in a USB jump drive, the depositions, and shall provide the same to a representative of the Orange County Jail on August 10th of 2024 at 9 a.m. Prison break investigation shall file with the court a notice reflecting that the discovery and the USB jump drive, which contains the state's digital evidence, was provided to Major Malik X. Muhammad at the Orange County Jail, including the date and time of the transfer. And so it goes on, as you can see. So it goes on. The point of this document, really, that I can get from it is that her motion was granted. Oh my goodness. So this document is 17 pages long, but they just detail it like that. They say the defendant shall provide to the court any and all written objections to the state's digital exhibits no later than August 23rd of 2024. This deadline may be extended upon a showing of good cause done and ordered in chambers at Orlando, Orange County, Florida on this 9th day of August, and signed by the judge Michael Korenick, circuit judge. And the rest is just citing, you know, other cases as reference. As you know, I'm not a lawyer, so citing that as we know. Okay, so then I just want to show you what it is. Okay, we go down like this. You see there? All right. So now what we're going to do is we will be looking at her letter written on August 7th. And yes, we'll look at this one as well, which I'm sure you guys know by now. If you are following the case, you might have seen this everywhere. Where she was literally advertising, like, look at this. It's like a billboard. Where inmate seeks attorney. This was before it was decided no more attorneys for you. Okay, you're going to defend yourself. And she's like, looking for a prosperous challenge, ready for your close-up on national television. Are you zealous with a side of keen? Like, what? Look at this. Oh my goodness. So we'll look at that as well. But what I want to do now is first show you a clip from yesterday's hearing about Sarah Boone wanting to be unshackled and unhandcuffed in the courtroom so that we could see how that all went down. It's about 25 minutes, so it's only a segment of the hearing. If you want to watch the full hearing, I will link that for you as well. It was streamed on Court TV and Law and Crime, so you can check it out there. But I want to show you this so that you can see, how she had requested to not be handcuffed, shackled, all that, and just what happened. So let's look at it. Okay, so here we go. I'm playing it at 1.1 speed. As you guys know, I like to watch everything on 1.5 speed, but I wouldn't do that to you. You could change the speed if you want to. 1.1 is what we'll watch it at today.
But it was never proven, correct? Because it was dropped?
It was dropped. Doesn't mean it didn't happen.
Okay. I'll be working on the others with the corporals and the sergeant for the supposed non-compliance. Thank you for the dates and the information.
You're welcome.
Ma'am, do you have any other questions?
Do I need to supply anything for the 2018 domestic violence occurrence that you are referencing and applying?
It's already been dropped. I'm just telling you what the history is.
And you can still apply it even though it's not been?
Correct. It's in your history.
Okay. Thank you for the information.
You're welcome.
Any follow-ups, Dave?
No, Your Honor.
Fine. Thank you, sir.
Okay.
Anything else, Dave?
Nothing stated.
Okay. See Deputy Barnett here. Could you come up, sir?
This is the right judge for this case. Oh my goodness. Besides Judge Doro, which of course isn't in Florida, I wonder if there's other judges out there that have this kind of patience. It's incredible to watch.
Please swear or affirm that someone you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do. Sir, good afternoon, or good morning, rather. Can you state your full name and date of birth for the record?
My name is Chet Barnett.
And not your date of birth. Sorry. Could you spell your name for the record?
C-H-A-T-B-A-R-N-E-T-T.
And what are your duties and responsibilities here at the Orange County Courthouse?
I'm the Deputy Sheriff at the Orange County Courthouse. I work in courtrooms, I supervise squads, and I'm also in charge of training inside the courthouse.
Okay. Is there any training that's addressed with regard to other security measures other than shackles that may be provided for defendants?
Yes, we have an item called a stun cuff that is also used in the courtroom.
Okay, could you step us through what a stun cuff is?
A stun cuff is an electronic device that's wireless. It's boxed, secured to the leg. It has 50,000 volts, and it's able to be remotely sparked from a distance.
How is it fixed or placed on a person?
It's dual strapped along the calf of either leg. It can be hidden in the pants, and gives the ability to people to walk around.
And who is in charge of operating that device?
It'll be an assigned officer that's been trained in the device.
And step us through the operation of how that device is utilized or operated by that officer.
The officer will show the device to the subject or the inmate or the defendant. It will be secured with two straps on the leg. There is a waiver to be signed prior to being used, explaining when it would be used, if it was needed to be used during court, violence, attempt to escape, any actions that...
So I've got a stun cuff picture there. So they're saying it's a wireless device that gets attached to the defendant's leg. And so if Sarah Boone is not going to have handcuffs or shackles, she's going to have a stun cuff. Because of course, they've got to consider all the risks for security.
Lead to that level of use of the device. It's a two-step process, so there is no way for it to accidentally be set off. It has to be hit two separate buttons so there's no accidents. If it had to be used, it would cause a shock to the location on the calf, causing a great amount of pain, causing the defendant most likely to fall to the ground, and we could secure and take care of the situation.
Are there any other protocols or standard operating procedures regarding the use of the stun belt, other than what you've already identified?
Just to follow response to resistance policy.
Okay, and can you explain the response to resistance policy?
We have a level of response to resistance depending on what an individual does to what we would do. So if she was to attempt to escape or fight, we would use to match that level of resistance.
What is the level of resistance whereby which the...
Also, sorry that the sound's a little bit choppy. Obviously, we rely on the court feed, so just know I'm doing my best here with it. I've made sure to boost it a bit for you so that you can hear what's being said, but there's a little bit of like choppy background noise.
Stun belt would be deployed or utilized?
At this moment, it's at a level 3.
And what is a level 3?
Level 3 would be failing to follow directions and stuff like that. If we asked her to get up and move or not, or follow off order, we can use it. Most likely in the courtroom, we use it probably at the floor level. That is pretty much fighting, escaping, attacking the person.
Okay. All right. State, do you have any questions to Deputy Barnett?
No, Your Honor.
Ma'am, do you have any questions for Deputy Barnett?
I do, please.
Go ahead.
Tell me, what is the title of this?
Stunt cuff.
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 And you said this was applied on the calf or the ankle?
Yeah, the Achilles tendon area of your leg.
And is this something that does it need extensive preparation, or is it something that can just be put on coming and going from the courtroom?
We would place it on you before the court starts, and you take it off at court at time. We exit the courtroom. It takes a few moments, signing the waiver, and securing it to your leg.
And it's a one-time waiver?
Each day you have to recite the waiver.
Now, let me know in the comments if you think if Sarah Boone is found not guilty, do you think that she's going to pursue a law degree after this? Because I think it's highly likely. I think she actually wouldn't be too bad. Let me know what you think. I know that's a crazy comment, okay? But like, I could actually imagine her being an attorney. The way she asks questions, the way the way she's so persistent, she would make a pretty good attorney, don't you think? Oh my goodness. Okay, so
Okay, so there's no limit to how many times it can be put on and taken off, put on, taken off.
No.
And it's a very simple process to apply.
Yes.
And remove.
Yes.
Thank you.
Any follow-up?
Nothing to say. Quiet.
Sorry. Would I have my hands free, correct?
Yes, you would have your hands free either way. If you were wearing a leg iron, your hands would be completely free. Stunt cuff, same thing.
And then I would be able to walk?
You will be able to walk with the stunt cuff freely, yes.
So hands free and able to walk?
Yes.
Thank you.
Any other follow-up? State.
No, Your Honor.
All right. Can Mr. Barnett or Sergeant Barnett be released?
Yes.
Ma'am, can he be released?
Yes, thank you.
Wow, thanks, sir. State, any argument, any further witnesses, evidence, or testimony with regard to the defendant's shackle motion?
No, Your Honor.
Ma'am, do you have any other things that you would like to tell the court with regard to your motion?
I don't understand what Sergeant Burnett was that you all providing me an option?
There is Florida Supreme Court case law addressing reasonable measures for movement by a defendant in the courtroom.
So that is an option?
Yes.
Okay. Do I need to supply the information in regards to the supposed 3 non-compliance before that can actually be made an actual option?
I cannot answer that question because that would be me providing you legal advice as to what you could, can, or should do, and I cannot do that.
Would I be able to be unrestrained with that information?
I think that would come down to the argument of yourself and from the state as to what the local court has to consider with regard to your request and your motion and what the law is in the state of Florida.
If I may make it clear also, I'm simply just asking to be unhandcuffed so I can write and move properly. I'm not trying to maneuver the courtroom and so on and so forth. I simply just am asking to sit here being unhandcuffed so I can write without taking skin off of my wrist and being extremely uncomfortable.
Okay. Ma'am, thank you for that clarification, because when I read your motion, you asked to be unshackled, to have freedom of movement, and I interpreted that as you wanted to move as everybody else may be able to move in this courtroom, as Mr. Cacciatore has moved around, how other persons have moved around. And it wasn't only limited to your hands. I thought it meant to your entire person based on what it is that you were seeking in your motion. So just for the purposes of my own clarification, is your motion only seeking to have your hands not bound so that you can move your hands, but otherwise shackles that may be on your legs would continue to stay there?
Right. I don't currently have shackles, but I don't know what is in regards to trial procedure. And in regards for you not having the clarification of me just wanting to be unhandcuffed, is it my responsibility, or I don't know if you can answer this, but you don't ask questions, which is what got me in this predicament from the get-go of having no counsel, because no questions were ever asked to me, just for the majority of my motions and letters and so on that I
It's everyone else's fault that she's now in this position. Okay.
have supplied the court for more information to try to intervene and help. It's just gotten me into hotter water and no counsel and still restrained. So is it something that I need to specifically clarify going forward, or is it something that you have the ability to ask me questions so you have a better understanding?
Generally, I don't know that I can answer that question because it may call for me providing legal advice. If I'm asking questions, it's because I'm trying to clarify things from my understanding. I cannot ask questions on your behalf. I cannot ask questions for you. I cannot assist you in any process, be it this hearing or at trial.
Right. Yes, I understand. I wasn't asking for assistance. I was just trying to understand. By you not asking questions in regards to my motion about being unhandcuffed and unshackled simply meant just my handcuffs.
Ma'am, I reviewed your motion to be unshackled, unhandcuffed, and allowed reasonable freedom to movement and functioning accordingly, equally, and comfortably while utilizing the courtroom. All normal movement of the defendant's hands is as a whole freely, properly, successfully accomplish any task that is needed. Asking to be unshackled and unhandcuffed, the defendant is simply requesting equal, comfortable, functional movement to achieve advancement in her forfeited right to counsel by the court, which will greatly enhance the productivity and progress for the defendant and the completion of her defense in her criminal case in preparation for trial. Your wherefore clause specifically asks to be unshackled, unhandcuffed, and allowed reasonably freedom in movement to function equally, accordingly.
The camera person, I was like, we're zooming into the handcuffs. They're pink, right? I was like, is that, when I first saw this, I'm like, am I seeing things or are these pink? I think they're pink handcuffs, but okay. Zooming in now to the handcuffs that are being discussed.
Comfortably in the courtroom. I took that as you wanted to move around. You did not want to be shackled, which would be your legs as well, and you did not want to have handcuffs. If you're telling me now that all you're asking is your hands to be free, that's respectfully not what your motion says over and over and over again, as I've just read. So if you would like to clarify for me now at this time, you can, as to what it is that you're asking of me.
Yes. Handcuffed. I would like to have these handcuffs removed from my wrists.
Okay.
In regards to the unshackled, I know at some point I would have to maneuver, I'm guessing, in the courtroom for trial. So I didn't want to have to wait last moment to have to do another motion to be unshackled if that's what my option is, because I don't know. So I was just trying to be transparent prior so you would know what it was that I was hopefully expecting. The first is just handcuffs mean unhandcuffed, and if for trial I have to be shackled, to be unshackled.
Okay, and when you say unshackled, what do you mean by that? Just so that we're all in the same field.
Shackled, as far as my understanding is from being shackled, means that I have this along with my waist, along with my ankles. So unhandcuffed is simply for the hands and the wrists, and then unshackled would be for my ankles and for the feet.
And is that what you were seeking for trial purposes?
I didn't know if I was going to be shackled or not, so that was why I was trying to be transparent and up forward by doing so now, to make the court aware that that would be a request of mine at the time.
Okay, all right. So you would be seeking to be unshackled, no leg restraints, no arm restraints at trial, right?
Please.
Okay.
Yes.
Would you also be asking of the court to move around the courtroom when trial would take place?
I'm not sure if this is considered legal advice, but I don't know. I know from seeing other trials, the state and the defense, they maneuver the courtroom in front of the jury, so on and so forth, and they hand things back and forth. I would have to have other movement other than me sitting here. So yes, I would have very limited, reasonable movement in the courtroom for trial, okay. Yes.
Is there anything else, ma'am, that you would like to tell me with regard to what you were seeking in your motion to be hands-free, for lack of a better word, during any hearings that we may have, and then to be hands-free, unshackled with your legs, and to have movement in the courtroom during the course of the trial? Is there anything else that you'd like to tell me about those requests?
I don't know if you've been able to see my difficulty with just simply trying to take notes. Yes, very much I would like to be unhandcuffed, just to sit here and be in attendance of my hearings, conferences, whatever it is. For the trial, when the time comes for any limited movement that I would have, the stun cuff, I would sign the waiver now. Just whatever it is that I can do in order to enable myself to be able to have the same comfortable atmosphere and movement and equal opportunities just as everyone else.
Okay, thank you. Anything else you'd like to tell me, ma'am?
No, Your Honor.
Okay. State any argument.
Your Honor, you've heard the Sheriff's Office's position. They're in charge of courtroom security. They presented basically their position is she should not be unshackled, but you've also heard from Deputy Barnett who explained the options that are available to the court. Our position is if you do not allow her freedom of movement with the stun cuff, then today is probably the best day to start talking about the logistics of how we're going to do this trial so it does not create the inference that she is an inmate. Does that mean the state will be sitting at the counsel table to question witnesses? How are we going to go about getting back and forth to the clerk and to the witness to present exhibits if she is not going to be able to do the same with shackles? So we just want to bring everything to the court's attention so we can get it all settled today.
I agree, which was the purpose of why we wanted to set it for today, to address all those circumstances and again, think ahead. Ma'am, do you have any closing remarks or arguments that you'd like to make to the court about your desires to be unhandcuffed, unshackled, and or utilize the stun cuff?
I believe that it is unfair that you, number one, want me to represent myself, and then number two, you would like for me to represent myself while being handcuffed, to be able to progressively and actively participate properly in the same as others with just simply being able to write notes. At some point, I'm sure I will be bringing things with me to court that I need to reach for, to open, to pass normal functions in a body as a whole with the same equal level as anyone in the courtroom would have in order for myself to be able to do the same and function fairly and appropriately. I don't know if this is legal advice or not, but in a trial, are you able to tell me are defendants shackled, or is this something that I don't even need to worry about because they're not even shackled?
But she's watched other trials. Don't you know, Sarah Boone? Because she knows everything, remember? She excels at everything. She knows everything. If someone's thinking, why the snark, Gisela? Why do you say that? Well, again, you got to do some homework. My goodness, this one, she believes that she's the best, okay, at everything. She was the best at school. She's the best at everything. And I think she thinks she's going to be the very best attorney. I mean, are we surprised that it got here? Are we surprised that she's defending herself? I mean, this is how it seemed like it was always going to be, right? So anyway, let's see what else she says.
Typically, ma'am, the defendants have leg shackles that, as Deputy Lowton identified, they're wrapped so that they're muffled, so that they don't jingle jangle or bring any noise attention. And the privacy panels located in front of defense counsel's table would prohibit the jury from seeing those. Their hands are free, but the legs are in restraints.
Thank you. Yes, I very much would like to be unhandcuffed just to simply take notes and function normally and equally just for hearings and so on and so forth, which we have a lot scheduled futuristically. And then when trial comes about, either way with trial and or hearings, the stun cuff, I am readily awaiting for that to be an option and to apply as soon as possible. Whatever it is and however it is that I need to, just to at least just have these removed.
Okay, got it. Any closing remarks, Mr. Jay?
No, I just address all the concerns which weren't the court's plan.
Got it. All right, thank you very much. I think the Florida Supreme Court has given us the guidance specifically for a case just like this in Weaver v. State, 894 Southern 2nd, 178 by the Florida Supreme Court in 2004. In that case, there was a pro se defendant who was representing themselves who had been charged with first-degree murder, and there was no prior history of violent courtroom outbursts. The defendant in that case was representing themselves, and there was some concerns as to being allowed to move around the courtroom during trial may present some safety hazards. The court identified as there would be, in our case, potential sidebars, access to witnesses, evidence, jurors, etc. And that in that case, Weaver's pro se status meant that he would be moving about the courtroom in close proximity to the judge, jurors, prosecutors, witnesses, and potential firearm evidence. This closer proximity to various trial participants arguably raises greater safety concerns than a defendant who is represented by counsel and has no legitimate reason to wander beyond the defense table. Given those circumstances in which a defendant is charged with first-degree murder who is representing himself and moving about the courtroom in close proximity to trial exhibits, especially adverse witnesses, the trial court did not abuse its discretion, even though Weaver had no prior history of violent courtroom behavior. In the Weaver case, the Florida Supreme Court found that the trial court's utilization of the stun belt was not so prejudicial when measured against the other alternative forms of restraint, and whether those alternatives are less prejudicial or viable There was virtually no alternative to a stun gun, given the visibility of other restraints and the security concerns posed by Weaver's pro se status in that case. It is clear as a matter of Florida law that a criminal defendant's right to be free of physical restraints is not absolute, and that under the circumstances in the Weaver case, the decision to employ a stun belt constitutes a rational exercise of the trial court's discretion that was reasonably necessary to ensure order and safety in the courtroom, especially in light of the defendant's pro se status. In that case, we had a firearm. It was a first-degree murder. Here we have second-degree murder. The incidents identified by Officer Lotan as to non-compliance in jail for purportedly refusing to return to show up in court, and the charge itself. The charge itself has some level of concern because it is a second-degree murder, but I don't see how where we are right now is not on all fours with Weaver, especially coupled with Ms. Boone's acquiescence to utilizing the stun cuff and saying she'd sign the waiver today. She doesn't have to. You'll have to sign the waiver when we get to trial. So unless I hear anything alternatively from the state, the courts would grant the motion that she would be unhandcuffed for any hearing we have moving forward. Instead of her position in the box, we would probably have her seated at counsel's table, unless I hear an objection from the state as to that. We'll address motions first. State, any position with regard to being unshackled and B, being seated at counsel?
So now we already saw the document that this motion was granted, which means if you see her in future hearings, upcoming hearings and things before the trial starts on October 7th, then you probably won't see her in handcuffs anymore, and she's going to be writing a lot of notes.
Counsel's table for any motions moving forward.
No, we defer to the court and the sheriff's office, who was in charge of security. Our concerns are just making sure that she's given a fair trial and fashioning a remedy that is a fair presentation for the jury to observe.
Okay, perfect. Thank you. All right, so now the court's going to grant your motion, and then you will be unhandcuffed for every hearing moving forward. And instead of being in the jury box, you'll be seated at counsel's table. Okay, you may still have your leg restraints on, but you'll be hands-free. For the purposes of trial, in accordance with the Florida Supreme Court decision in Weaver, you will be hands-free and you will not be shackled with legs. But the stun cuff, as identified by Sergeant Barnett, will be affixed to you, and you'll have to sign that waiver. Do you have any questions for me, ma'am?
For sitting here in the counsel's table, you also said that I would be shackled. I'm not shackled now. Will I be shackled then?
My understanding is that you were. If you're not, and the only thing you have is your handcuffs?
Correct.
Is that correct?
Correct.
Okay. If that's the case, then you'll be seated at counsel's table with that, as you are without your hand restraints.
Okay, so I would be unbound.
Correct.
Yes, thank you.
All right. The other item I have on, yes, sir.
I think the sheriff's office is looking for clarification, and I think I am too.
Okay.
I think the situation is because she has handcuffs on now, she doesn't have leg restraints, but for hearings, when her hands are unrestrained, her legs would be restrained.
Okay, I'm getting a thumbs up from the deputy in the back that that's the case. Is that the standard operating procedure, Deputy Logan? Okay, so ma'am, so I'll clarify my order. For the purposes of any hearings, you'll be hands-free, but you will have leg restraints.
Yes.
That's not going to affect any fairness or impartiality because it's just you and me and the state, and no jurors will see that. Yes,
Also,
sir.
Judge, when she's being transported from the jail, she is going to be fully handcuffed with belly chains and all that. We can take those off
In
when
advance.
she gets up here.
Yeah, I understand that. I'm just worried about the fairness here in the courtroom, especially when we bring in a jury panel. Okay. And for the purposes of trial, ma'am, you'll have no leg restraints, no hand restraints, your hands free, legs free, but you will have the stun cuff affixed to your leg. And as identified by Sergeant Barnett, you're going to have to sign that waiver every day, okay?
Of course, and if I may, if anyone knows, the stun cuff, does it go over clothing or does it have to
It is under your clothing, as Sergeant Barnett identified. I have a representative from the Public Defender's Office who I've asked to be here. She's going to have a conversation with you, ma'am, after our hearing, so she can facilitate clothing for you, including pants that would prohibit the jury from viewing that device on your legs.
Yes.
Okay?
Thank you.
All right. Does that clarify for you, State?
Yes, I just saw them and I thought that I saw the.
Who thinks that she's going to complain about the pants that she's given? I think she might. I think she might be complaining about the outfits, that it's not her color, not the right fit for her to defend herself, okay? But let's see if that does happen.
Confusion based on my experience and how it's done.
Okay.
We cleared it up.
Thank you. Now, ma'am, that doesn't mean that you're going to be able to wander wherever you want in the courtroom. There's going to be spots where you're going to be able to go to. You're not going to be able to walk all the way up to witnesses. You're not going to be able to walk everywhere that you want. There's going to be places that you're going to have to go to. When we get closer to trial, we'll address the box, for lack of a better word, for where you'll be able to go and not go. And I'm going to give the same limitations to the state, okay?
I understand.
All right. Are you okay with addressing that later, counselor?
Yeah, I mean, what I would envision is if she needs to consider brought to witness, I have no problem getting up and doing that for her.
I was going to, either you can do it or I was going to have the deputies do it.
Okay, so if you want to watch the entire hearing, as I say, I'm going to link it for you in the description box. Now, let's have a look at some of those letters, some of Sarah Boone's latest letters. Okay, so here we go. Okay, so as you see, this one is from July 8th of 2024. Remember to use the timestamps in the pinned comment or the description box if you wanted to skip ahead, if you already know all about this letter and you don't just want to skip to the next one. This next one we're going to look at is actually dated August 7th. So this is the latest one. We're first going to look at this one from July 8th because I had not covered it and it is quite something. So Sarah Boone wrote this letter and said, Honorable Judge Michael Kranick, and she said, received from Judge regarding Sarah Boone, case number, she says, one on many websites, okay, and she's got it listed there. Judge Kranick, where is my discovery? I am still waiting for you to provide me with the contents of what former attorney, I just want to make this bigger, there we go. We don't want to miss a word. On what former attorney Cashman supplied to you and the court at the surprise status hearing held in secret on 6/28/24 at 1:30 p.m. Your designated clock of unfair judgment ticks empty and incessantly while waiting for you to deliver. Oh my goodness. As usual, it's in your favor. In your nonchalant, relaxed, unconcerned attitude of me to receive, you are robbing me of precious, life-saving time to fully and properly defend myself on top of my already and still being violated constitutional rights and being forced to represent myself based on false information. I do not even know what is contained in said discovery after being withheld from seeing all to date, and for the first time in said surprise status hearing, along with my supposed digital evidence being produced by Cashman, finally, after never being shown any of during her representation. Her response to me, when I would ask to review, was, your first attorney said he reviewed with you. That was over 4 years ago. You're my attorney now, and no, I did not. This is what I had to deal with. I have not seen in its entirety and completely to date. Please note, I do not have access to a computer to view these materials. I'm doing my very best to figure this out, figure this and everything else out, there we go, as I go in my newly unwanted, forced position of pro se. Please do not penalize me even greater than being already. I'm trying. Oh goodness, okay, so please know also, I am in an open bay dorm, living with, 63 other inmates. I need to figure out how to view anything securely to avoid further exploitation and mean ignorance. There's no privacy or individual access in jail. Okay. Cashman, I'm glad I could help you shine in the courtroom in front of the judge by you professionally and finally bringing everything I've been asking for since day one. And after I included you on my letter to the judge, ensuring return. Okay. Unlike you, who did not include me on your motion to withdraw. Surprise! And I to find out from someone else, an officer, 3 days before this surprise status hearing, so you would even know what to bring. Why didn't you bring to any of your 20 hours of meeting with me? As always, it's in everyone else's favor but mine. How much real time will I have to prepare and properly, especially the fact that you have me doing everything while incarcerated? What happens when more time must be utilized to discover where my lost discovery is I've been asking for repeatedly? For depositions, to locate my witnesses, To locate my witnesses. Okay. Contact anyone via collect phone calls. That's a real hurdle. Wait to receive transcripts, any records, everything I need to finally build my defense. Or is your plan, Your Honor, to just leave me out to dry? And in a hurricane. She's very dramatic. My goodness. Oh my word. Okay, so we're on page 3 of 7. Your time constraints are extreme and unreasonable. Your decision you claim to have considered from your order is illogical and unfair, especially that it has been malformed by your ignorance and experience of my case. Wow. Misinterpretations, straight lies from the attorneys appointed. They are brazen to stand at your pulpit in your courtroom and commit perjury to your face and the world. But yet, it's me. It's my belief, and from your order, that actions speak louder than words. The court is sabotaging me, forcing me, pressuring me, setting me up for failure. If any of the prior attorneys would have included, cared, collaborated during their time of representation, you, not being brainwashed, impartial from believing everyone over me, and implementing your intricately misconstrued, unfair order formulated from, I would not be writing yet another letter, would I? In the meantime, while your clock ticks ceaselessly and loud as I wait for you to deliver anything, even more fingers are noticed. They really do point back. Even more fingers are noticed. They really do point back. And I am defending myself against your inaccurate, libelous, I can write letters to order. Please, would you post my included document in your break room? Okay. Wherever you think it may be seen and understand or understood, like unlike me in your courtroom, it's like very pick-me attitude, right? How about by the copy machine, where your JAs, I think that's what it says, should have made me, the news crews, court TV, professional YouTubers and photographers, the world, a copy of the notice of hearing where all aforementioned improprieties occurred and then some, including the drop-off of my case, of my case materials, said order being ordered and me being pulled by my uniform to exit your courtroom while still trying to speak and defend myself against all the mayhem and chaos, especially the surprise of even being there unprepared and without notice. Oh, wait, my posting, everything supposedly is public record and there's no notice at all. Another, it's in your favor moment. It's a group effort. Sabotage. Surprise. Well, she says surprise a lot. She's very upset about the surprise hearing that was had. I shall return. Nothing is impossible. Believe. Hopeful, grateful, waiting. Thank you for posting, Sarah Boone. Remember, please, Judge Koenig, fair, neutral, impartial. You must be, always. And then she makes a little heart and says, I can do all things through Christ who strengthens me. I feel like she's saying it in a very threatening way. Let me know how you read that. Okay, now we get to the infamous poster that she's made. Arrows. Inmate seeks attorney. Looking for a prosperous challenge? Ready for your close-up on national television? Are you zealous with a side of keen? Show the world who you are with your original creativity, extraordinary expertise, confident ingenuity. Qualifications must include being trustworthy, honest, passion-driven, open-minded, exceptional problem-solving skills, client inclusion at all times, team orientation, collaboration, extreme efficiency in listening. Wow, extreme efficiency in listening. Like, listen, man, I'm going to tell you once and you're going to understand, okay? Wow. Okay, communicating, understanding, dedication to success, possessing a winning mindset, capability of excellence in representation, committed, maintaining faith in the client and case with the ability to think differently, overcome all circumstances. Epic opportunity awaits. Sarah Boone, number 205623, Orange County Corrections Department. Invest in the oppressed. Believe. Well, she's very creative. I'll give her that. My goodness. Oh my, and there's the envelope. Okay, so now we get to the latest letter. Dated August 7th, 2024, of course, 2 days before this hearing that we just watched. Captain DeGiovanni, Orange County Corrections Department, reply or from Sarah Boone or regarding Sarah Boone, questions, concerns for laptop, phone, etc. Captain DeGiovanni, thank you for your timely cooperation and assistance in me receiving my laptop yesterday, 8/6/24, and 2 Discovery USB drives supplied by my investigator. I am attempting to fully maximize my opportunities available from OCCD to thrive in my forced position as court-appointed pro se defendant and the success of my case. I want to excel in my present circumstances by attempting my best, and have been since day one of my incarceration, ongoing 5 years ago. As you can imagine, I do not want to be here any longer, ever. With the hopeful, effortless cooperation and attentive care from yourself and OCCD, I believe that I can achieve more efficiently, effectively, equally, so I'm able to plan my very overdue exit in the very near future. My goodness, if she's convicted of second-degree murder, she's gonna, or manslaughter, or whatever, if there is gonna be a lesser charge, wow. Or imagine if there's a mistrial or something, she's gonna be shocked and of course pissed off, of course. I'm just saying, like, damn, she really is like, hello, I'm trying to get out of here immediately. I have been instructed to contact you directly for the listed questions and concerns to hopefully remedy or provide further insight to for completion of, so there is a universal understanding to enable me to produce greater, faster results work product in my case and defense. Thank you in advance and profusely. I think I should start signing off emails like that. Thank you in advance and profusely. My goodness. Okay, 1. Laptop times. Extend from 8 a.m. to 4 p.m. to 7:30 p. to 10 p. So I'm guessing she wants it more in the evening, right? I'm willing and need to vigorously work on my defense as often as possible. I do not think I should be restricted to daytime use only. After 4 p.m., I do not have access to the laptop, which equals 0 work, product, and progress. The building of my defense is halted for 16 hours until the next morning. Request, extend times to use by 2.5 hours in the evening. 2. USB drive security. As stated in court to the judge, I do not feel comfortable in handing over the entire contents of my case to the miscellaneous officer in the dorm for the day. All my information is highly confidential, and I'm trying to avoid further leaks on top of the already recorded jail phone calls, visitation names and details, my inmate interactions, meals consumed, etc. A concerning example today, I returned the laptop and USB drives together yesterday. I received back the laptop, which is not charged at all for instant use. Oh my goodness. That laptop should be charged for instant use. And the USB drives separated with the protocol security paperwork removed I needed, and then both bags resealed. Another example, I went to pick up everything in the morning and the officer removed both USB drives from the bags before giving to me. Who is in control of the laptop and my 2 USB drives when I return at the end of each day? Where do they go? How are they secured? Why are contents being removed or opened? As said, I do not feel secure in this process, if there is one, and it is vital to me that OCCD handles with priority, safety, security, and care when asking any officer anything pertaining to the laptop and drive they do not know and become agitated with me trying to ask and figure everything out. Request, allow me to keep only the 2 USB drives I think this is, does it say new? I think it says at my bunk. There we go. After returning the laptop, to keep in my secured, locked drawer each day, a hopeful evening. She wants the laptop at all times, basically. 3, classroom. This room is unoccupied for the majority of each day and on available close and undisruptive solution. So, an available close undisruptive solution for me to achieve privacy for reviewing and listening to my confidential case documents. The classroom is also in direct, continuous, effortless view of the officers at all times. Request, permit me access to utilize a table in the classroom to view and listen to my discovery on the laptop when not occupied and is in direct view of the officers. 4. Earphones or headphones. As said, my discovery contains a large amount of audio to be listened to. If you will not permit me access to the classroom, I will need listening abilities with earphones or headphones over the ever-increasing noise level of the dorm. There's also a what on the dorm? Something. There is also when the dorm is on lockdown. I don't know what this word is. Okay, there's also something when the dorm is on lockdown and quiet, so no one is able to hear. If you know the word, please let me know in the comments below. If you see that 20 other people have already commented, don't also comment it because then I can see it, right? But if you see there's no comments yet, what the heck is this? But there's also when the dorm is on lockdown and quiet, so no one is able to hear. Request, provide any kind of earphones or headphones. 5, internet with limited access and restrictions. I need to research heavily my defense, all of it. Locate witnesses, any experts, the clerk's website, correspond with the judge. Oh dear, poor judge. Okay, my defense team, that's herself, of course. Anyone affiliated or maybe with my case, forward motions, other important documents, everything I need to educate myself on being pro se, etc. Please understand I cannot complete any of the above mentioned without internet. The basic laptop provided is only for viewing my USB drives. There is no other access. Request. Grant me access to the internet with appropriate parental controls in limited access with restrictions. 6. Word program. We're on page 5 of 8, by the way. To type any motions, make notes, lists, names, anything I need to document and record for future reference or sharing with potential team members. No, team, right? Team collaboration as opposed to said. I need to be able to open and create a document, save work product information, attach text or PDF documents created to email if granted, print needed documents or discovery pages for mailing, sharing, presenting, or distributing. Request, permit access to Word program to use fully, properly, and progressively. 7. Telephone access. As you're aware, my dorm contains pay phones only and are limited to only 15 minutes per call, which are collect. I need to be able to communicate on a regular, normal phone to make any or all necessary calls for my case to use in the trial. I have no other way to contact anyone that is not collect, which incredibly diminishes most, if not all, of my opportunities to properly prepare. Request, permit me access to a regular normal phone to communicate reasonably with the parties in my case and only new futuristically to be affiliated with. 8. Discovery hard copies. As I am presently, I can keep these in the permitted property bag discreetly located at my bunk. I will purge the documents I have now and keep only my discovery hard copies. The remaining I can send to the property department and will purge anything already being stored for easy convenience and extra space. Also, when the laptop hours are closed, I am able to pick up uninterrupted with these hard copies at any time. Any comparative review with the digital can also be achieved. Request. Permit my hard copy discovery to be received and kept unnoticed at my bunk for readily available viewing and unrestricted access to. Captain De Giovanni. Everyone's understanding and invaluable time is greatly appreciated in the assistance in aiding me to utilize my capabilities and opportunities here at OCCD. I am diligently working on what I can with what I have, a laptop and 2 USB drives, and am severely hindered in real progress without my request, especially needing to access the internet and a normal functioning telephone. Becoming pro se defendant was not my choice. I'm already trying to overcome extreme circumstances just in my life of incarceration, and now in addition being forced by the court to represent and defend myself in my criminal case. Extreme has progressed to extraordinary. Okay. Please understand my attempts are always in good faith, where I am simply trying to complete these tasks needed to surpass my difficulties and achieve overdue success. Overdue success. Okay, and finally, I cannot do it without you and the assistance of the Orange County Corrections Department. I believe that was difficult for her to write. To admit she can't do it without them. Okay. To admit she needs help. I thank you everyone for your patience and await your response for needed collaboration and conclusion of my request, please, and criminal case. I have notified the judge also with a copy of their letter, so he is aware I am in the process of trying to receive these must-haves and that I need further guidance and answers from you first. From there, I can create all motions that may be necessary for access and completion. This is important, Captain, and time sensitive, as my as my proposed trial date is on October 7th, 2024. As of this letter, I have only 59 days for the completion of my defense. Oh dear, prior. Please understand the importance of your timely attention and response. As said, I cannot do this without you and the help of OCCD. I am beyond grateful. Please notify me as soon as possible, please, about any motions I need to file for my request to be granted. Thank you immeasurably. I do like the way she signs off. Profusely. Thank you immeasurably and profusely. Sincerely, Sarah Boone. And then she signs and she said, pro se indigent defendant inmate. Sorry. Oh my goodness. It's just like the letter she writes. She said, I also spoke to Sergeant Casey in the courtroom requesting your time, please, at your earliest opportunity to convey the importance of my request to hopefully be completed. And then at the bottom it says, copy to the judge, hand delivered. Sure. How do you feel? Are you feeling exhausted, drained, entertained? I don't know. Like, wow, Sarah Boone is on another level, that one. My goodness. I do think the trial will be very interesting. Maybe I'll cover it. Who knows? Who knows? Let's see. If you guys are interested in that at all, please like and share. And let me know if you want me to cover other updates in this case. Of course, sometimes I wait for many updates to stack and then we just do one video looking at all of that because my goodness, I personally find Sarah Boone very exhausting. Okay, I know she has the right to defend herself now. Of course, she's worked through many lawyers and most of them have run away. Some were conflict of interest, but wow. I mean, she is an absolute handful. So let me know if you want me to keep updating on this case. By the time we look again, by the time we blink, it's going to be October 7th. You know how time flies? I mean, we're already now, it's August 10th at the time of this recording. When we blink again, it's fall. It's October. October 7th, the trial should start then. Of course, there's been many delays, but the judge is saying this is when this trial is now going to start. So I really hope that it will. I really hope it will, because it's been a long time, right? And of course, George's family deserves full justice. I mean, being zipped up in a suitcase and then forgotten about, which is the story, is horrendous. For him to die in that suitcase, and she's all about now, of course, her defense and her comfort and, you know, her risks and her writing. But like, what about him? You know, there was no such concern then. In fact, it was pretty sadistic. The way, well, that's an understatement, filming him and calling him an idiot. Of course, she was, it seemed like she was very drunk at the time as well. But that's no excuse. I'm just saying, like, my goodness, to film that and then forget that she filmed those videos. Whew, my word, it's just so cruel, you know, what happened to him. So I'll keep you posted, of course, if you want me to. And I will see you in the next one. Stay safe.